covering. We're going to go through the cases because I can, in good conscience, not have you read the cases, just in case somebody doesn't like my just very descriptive and thorough dissection of all these rules, and you need cases to make you or help you understand these rules of law. We're going to read the cases. We're going to get through the cases. I want to be very concise with these cases so we can cover everything. I want to get, most importantly, what is the rule of law that came out of each of these cases? Trying to make sure that we stick only to cases in which the rule of law is, so that we're not repeating certain issues over and over. All of the cases that we're doing will teach you a new area or rule of law. So we're going to start today with statute of frauds. We finished last week with 281. Statute of frauds, we're going to, I know I gave you a homework assignment regarding statute of frauds. You all know that my legs is covered. That's what's covered under my legs. My legs is a general rule, and I believe I asked certain students to tell me what each of those elements are. I did write them down somewhere. Oh, right here. I've got them. And then I also want to know what the exceptions, if any, because that's what I care about, exceptions. Everybody's going to know the general rule, but where you're really going to set yourself apart is really knowing the exceptions, and guess what? Exceptions to exceptions. Okay, so you're going to know those. And then we're going to get to one of my favorite areas, parole evidence. Why is parole evidence my favorite? Because I struggled with it in the beginning. I used to be in the TA's office hours a lot, and I was like, I don't get it. I don't even know how to spell parole. I keep adding an E, and I'm confused. And it's very straightforward. It's very simple. I will make it very simple for you, the way that my contracts teacher did not, so that you too know and like and understand parole evidence. So, let's just get through what we need to get through. Okay, so statute of frauds. Let's start with Sam. You're going to tell us about suretyship. What is that word? Where's the eraser? And why do people take supplies? That is so rude. It's not like anything.
General rule is a promise to pay the debt or duty of another is within statute of frauds and therefore unforeseeable unless applied.
You look so happy to be giving this to me. Okay. Well, listen, if you have bronchitis or pneumonia, this is the class. Because everyone here can give you some piece of advice. Okay. What is suretyship?
Promise to pay the debt or duty of another, and that's within the statute of frauds, is therefore unforeseeable unless in writing.
Okay, and now, besides promising to pay the debt of another, what specifically, what type of debt, what are the nuances of a suretyship that we need to know? For example, let's say that the debt that I'm paying on your behalf in some way, shape, or form benefits me. Is that still going to be considered a suretyship?
No. If the guarantee was a benefit to the guarantor, then the guarantee need not be.
Okay, so promise to pay the debt of another requires writing. Yes? Okay.
However, if the writing doesn't have to be written at the time of making the promise, and the main purpose of the obligation is basically allegedly guaranteed was to benefit. Okay.
Read it, and we're gonna dissect it and synthesize it together.
All right.
So what's the main purpose? The main purpose of paying a debt of another has to be what? Does it have to be completely, basically completely altruistic, deed? Denise, do you not? Okay, means something 42. I think, I'm not sure. 42, is that what I said? Okay, here, I'll read it. I'm not fun doing this together. And these are the things, so if you were to talk about understanding a rule, C- student understands you're promising to pay the debt of another, therefore it has to be in writing. Okay? That's your basic, bare minimum, skeleton bones understanding. When you understand what type of promise it is, meaning it can't be one that you are benefiting from personally, that you would be either A, on the hook for as well, or when you understand the main purpose, that's another step towards having a deeper understanding. So we're going to get through the entirety of the rules so you understand this rule in depth, okay? So 42, let me see. Intended. Okay? Questions from here? No? We're all okay? We're all together? Is there writing? Number 2 is the writing integrated? Meaning, is it intended to be final? Yes, I know we're talking about that, people. What actually has to be written down? No, that's not what I'm asking you. What terms? What provisions? Is it your name? Is it the date? Is it a signature? What has to be written? What is the evidence that the court's going to look? What? Okay. The statute of fraud does not require a formal contract. Among other things, the writing could be a receipt, a letter, a check with details in the memo line, or a written offer that was accepted orally. The statute requires only one or more writings signed by the party to be charged, and I've explained this to you before. Who is the party to be charged, and then we can talk about has anyone been watching the news with the Trump and the Stormy Daniels issue? Because this actually comes up, the party to be charged issue, and her attorney goes on the record stating that it's not a proper contract, non-disclosure, because Trump didn't sign it. And we'll go into, once you understand what the party to be charges, we'll talk about why he's wrong. Okay. What's the party to be charged? Who is it? The plaintiff? Are you sure?
Oh, the defendant is a defense.
The party to be charged is always the person who is going to be sued. At the time of the formation, you don't know who the party to be charged is. That means once you make the decision to sue on behalf of a contract, okay, and you know that there must be a writing, and you find that contract in your drawer, and you're looking at everything, and you notice that the person that you want to sue doesn't have a signature on that piece of paper, you're kind of out of luck. It doesn't mean that the contract wasn't valid at the time you formed it, but it means if you want to sue them on it, you're going to have a very hard time getting around that issue. Guess what, though? They could sue you on the contract if you breached. Your signature's on it. So then you could be the defendant. So, okay. That's the party to be charged. The person who is going to be sued or being sued. So if there's a chance you want to sue that person on the contract, please get them to sign the contract, okay? The statute requires only one or more writings signed by the party to be charged. I'm reading on page 41. That 1, reasonably identify the subject matter of the contract. 2, indicate that a contract has been made between the parties. 3, state with reasonable certainty the essential terms of the unperformed promises. Example, Becky Baker calls Sam's supplier and orders 2,000 pounds of flour for use in her bakery at Sam's price of 70 cents a pound. As will be discussed, this contract is within the statute of frauds and is unenforceable by either party without some writing evidencing the material terms. Later that same day, Becky receives a flyer from another supplier indicating that their price for flour is 65 cents per pound. Becky immediately faxes Sam's supplier the following note. Please cancel my order for 2,000 pounds of flour. Signed, Becky Baker. Becky's attempted cancellation of the contract is sufficient writing under the statute of frauds to make the contract enforceable, at least against her. She signed it. Okay? Let me just discuss what essential material terms are. What do you believe are essential material terms?
Name of the parties.
What?
Name of the parties.
Anything else?
Subject, quantity, and price.
Yeah.
Right. If a writing does not contain the essential terms of the agreement, it does not satisfy the statute of frauds and cannot be enforced. Why is that? Why is there no contract? As a matter of policy, do you think that a judge wants to sit there and try and figure out how much flour you intended to sell somebody and how much at what price? To play babysitter to all these private parties who can't figure out how to put terms down in a contract? Can you imagine? Essential terms should be there, okay? Statute there's no definitive list of essential terms. They vary depending on the situation. What is essential depends on the agreement, its context, and the subsequent conduct of the parties, including the dispute that has arisen. There must be enough in the writing to enable a court to enforce the contract. If an element is contained in the writing, evidence is admissible to explain the particulars. So remember, you can always have evidentiary hearings to explain something if something is ambiguous, but there has to be enough there so that you can explain it if necessary by hearing, but you can't have it be completely void. You can't have it be completely blank and say, Your Honor, we agreed to 70 cents, and yes, it's not in here, but that's what we intended. The essential terms should evidence the intent of the parties. That is the purpose of a contract, to evidence the intent of the parties. And the four corners of the agreement, meaning the contract, should evidence everything that you wanted in that contract. Okay, when you see full and final agreement on any contract, which most any contract that says a full and final agreement, it means that the four corners of that contract cover everything that's intended to be in there, meaning nothing else comes in. Okay, whatever you talked about with the rental car agent before, and he didn't put in when he handed you your cars to your keys to your Ford Fiesta rental, if it's not in there with his hand notes, he was going to give you the extra GPS for free, it doesn't come in. Okay? So, okay, signature requirement. The signature requirement, and I want you to read that. It's a long paragraph, I don't want to take too much time reading. Well, I'll read you this. For example, the essential terms normally include the identity of the parties, description of the subject matter, and terms necessary to make the contract definite. If you don't know the answer to what are essential terms, just think back to Q-tips, okay? As a default. For example, writings evidencing land sale contracts must contain a description of the land and the price, and those for employment contracts must state the length of employment. For the sale of goods, the UCC requires only some signed writing indicating that a contract has been made and specifying the quantity term. Quantity is always the most important thing in the UCC, okay? UCC, when it comes to Q-tips, quantity is numero uno and price. Signature requirement. The signature requirement is liberally construed by most courts. The signature is any mark, not who has to sign it, but what is a signature, okay? Any symbol made with the intention to authenticate the writing as that of the signer. It need not be handwritten. It can be printed or typed. Under the UCC, even a party's initials or letterhead may be sufficient. That's why you can do all those DocuSign electronic signatures, okay? It doesn't have to be. Okay. Electronic signature, the signature requirement may be satisfied by an electronic signature. As with paper signature, whether a record is signed is a question of fact. No specific technology is necessary to create a valid signature. If the requisite intent is present, one's name as part of any email may suffice as a signature, as may the firm name on a facsimile. Okay. Okay. Got off topic, but now we're covered. We understand essential terms and signature. Okay. 3B, promises to pay debt of another. Suretyship promises must be a collateral promise. A promise to answer for the debt or default of another must be evidenced by a writing, which is why it's under the statute of frauds. The promise may arise as a result of a tort or a contract, but it must be collateral to another person's promise to pay, and not a primary promise to pay. Okay? Example. Give him the goods, and if he does not pay, I will. This promise is a collateral promise and must be evidenced by a writing. But if the promise is, give him the goods and I will pay for them, the promise is a primary purpose and need not be evidenced by a writing. Okay? Can you see the distinction? Do you have any questions? 2. Under suretyship, main purpose must not be pecuniary interest of promisor. What's pecuniary? Pecuniary. Good. Okay. If the main purpose or leading object of the promisor is to serve a pecuniary interest of his own, if I am paying your debt to better myself in a pecuniary matter, it is not covered under the statute of frauds. The contract is not within the statute of frauds, even though the effect is still to pay the debt of another. Okay? For whatever.
Possibly enforceable, even if it's an oral promise.
It is enforceable if it's an oral promise. Because I am getting a pecuniary gain from paying your debt, which would be
There cannot be rendered unenforceable by inspection.
correct. But if you see a situation like this, where somebody's paying the debt of another, and there's a contract, and there's no signature, or there's not a written agreement, you have to go ding, 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 suretyship, statute of frauds, okay, I'm supposed to be writing about that. However, conclude, however, this is not a defense to formation, and this contract is enforceable because it is not covered under the statute of frauds, because promisor is making a promise to pay the debt of another for own pecuniary gain. Done. Okay? So you're going to see situations like that, but you have to show the greater you know you understand the difference. Because you know it's not just promise to pay the debt of another. It's much greater and deeper than that. It's much more complex. Okay? I'm going to give you a pop quiz on this. Don't worry about it. It'll be fine. Okay. Example, okay? Ernie contracted with ABC Code to have some machines custom made for his factory. he promised ABC co-supplier that it would continue to deliver materials to ABC. Ernie would guarantee ABC's payment to the supplier. This promise need not be in writing because Ernie's main purpose in guaranteeing payment was to assure that ABC Co. had adequate supplies to build his machines. Okay? Now, the next one is marriage. We're not there yet. So, Sam, is there anything that I left out? I know this is your topic and it's your forum to talk about, and I just took it from you. No, tell us.
I read that the document signed by the surety will meet the requirement for writing if it's not addressed to the applicant. And even if.
Who's the obligee?
Well, it gives me an example on the bottom that gives me an idea. Might be the obligee in a situation where there's a person making a promise like the one that.
Okay.
I don't really know.
Well, we're gonna figure it out. We're here, working our brain muscles. That's probably misnomer, right? Because the brain is one muscle. I don't really know. Does anyone know? Or you would know this. Is the brain one muscle? Is it several muscles? I don't know.
It's not a muscle.
It's not? Mine is. It's a little peanut and it's so much. Okay. So, obligor, obligee. Who is it? Let's figure it out. In case you had to diagram this.
So, it goes on to say, even if it's not dated until long after the oral promises guarantee, even if it was never seen by the applicant. And it gives me an example of a situation where A oral promises meaning that A will extend credit to C, A will guarantee repayment. B extends that credit to C. 2 months later, A writes a letter to C stating, I am not sure that you need this, but I guarantee B that I will repay the debt if B is done. The promise by A falls within the suretyship provision. C is the primary obligor, and A is the surety. However, the letter to C satisfies the writing requirement, even though this writing was not addressed to me or ever sent to me. It is sufficient memorandum, therefore A's moral argument is enforceable against it.
C buys car from B. Okay. There's a debt. Right? What's C? Okay. And what's A? A promises to pay C's debt to B. A is the surety. Yes? Okay. So, I guess the creditor would be obligee, the debtor, obligor. A is the surety covering the debt of the obligor. Okay? Are we clear? Any questions? Shall we read the case on this issue?
Obligee is one who's doing this.
Correct. Creditor. Confused?
I said the opposite.
So, offeror is who? Making the offer. Offeree receives the offer from offeror.
That's why I got the obligee is the one that, in some sense, took on a receipt of debt.
I understand, but the obligee is the one receiving the obligation from obligor. Look at it that way. Okay, so Kristen, is this your case? Layman versus alumni? It is 294. It's a very short case. Did anyone cover it? I don't want to waste time if somebody hasn't briefed the case. So who has briefed this case? Who's read this case? Layman versus alumni.
Basically, one of the guys, he bought, it looks like an arcade from someone else, and I don't think he was told that it was more of a burden than it was an investment, and he wasn't told about some of the things that were inside of the contract. And he said a guarantee would accept the deed becomes contractually bound by its provisions. And what happened was he didn't know that some of the provisions that was in the contract when he purchased it was in there.
I'm not, for those of us that aren't familiar with this case, just go step by step. This,
The Alumni Association accepted a gift that later proved to be a burden. The gift was a deed to a commercial property called Ferdinand's Arcade. One of the donors was Dr. N.W. Layman. The association acknowledged the gift and had the deed recorded when the donors had bought the property. They incurred a debt and granted a lien mortgage on the property to secure the debt. The deed to the association referred to the debt and continued. Guarantee Association.
okay, stop. I want this case briefed, at least in a short, concise manner, rather than just being read out of the book. So I don't care who does it, but somebody's gonna do it. But for right now, I'm not gonna take the time, we're not gonna waste the time going through it until somebody's done that. And then we can have an intelligent conversation about this case. So we're gonna move on to the next case, okay? And we're gonna come back to this case and somebody's gonna have briefed it. And all I want is issue, what's the rule that came out of this case? Why do we care about this case? Give me a short summation of the facts and conclusion, okay? It is a little bit convoluted, so I will give you that. So kudos to anyone who takes it on. Can we go on to the next case? Actually, Central Ceilings is also in surety ship and main purpose. Did anyone brief that? No. Everyone forgot to brief cases. Okay. Jeremy, you did brief your case. No. Yeah, you did. I'm sure you did, right? I'm sure you read your case and briefed your case. So I assigned you case 303. Correct? That's fine. I'm just gonna read 299 and then we're gonna discuss, 1 year rule for, under statute of frauds. So we're gonna get off this for a second. Okay? We're gonna go to the 1 year rule and read Crabtree, but first I wanna read, 299. afford to waste any time, okay? And when you have a case assigned to you, you need to be able to read it quickly and get out of it what's important and be able to tell us what that is. Because we have a lot to cover and you all have final exams 1 month from today, I believe. Okay? And I need you all to do very well. Because you deserve to and you're all very capable. Okay, so 299. Satisfying the statute of frauds. If a contract falls within the statute of frauds, then it must be set forth in a signed writing in order to be enforceable, as it is usually put, in order to satisfy the statute of frauds. In this section, we will consider what must be in writing, what form of writing that must take, if it is to satisfy the part of the statute of frauds we've covered thus far. What constitutes the signature, the special significance in our increasingly digital age. Finally, consider how statute of frauds case arises. There have been no studies of who drafted the writings offered to satisfy the main statutes of frauds. One gets the impression that only a modest percentage of the reported opinions in the area are based upon contracts drafted by counsel. What might that tell us about how effective statute of frauds have been in channeling contracting parties towards desirable methods of reporting their contracts? How do formal requirements mesh with a contracting world consisting mainly of non-lawyers? And keep in mind that lawyers deal with statute of frauds in very different capacities. Litigators do what they can with the writings that the parties set down. Transactional lawyers seek to avoid statute of frauds dispute rather than to figure out what to do if a client brings a dispute to the office. How might a lawyer's different roles affect how lawyers view the statute of frauds and how they prefer it to be stated and interpreted? Okay. Now we're going to talk about another issue under the statute of frauds, which is the 1-year rule. Okay. Which is the Y in MY, my legs. So, Jeremy, tell us what we need to know about the year rule for statute of frauds. Is that you? That one? Oh.
You got the
Tell us what we need to know.
1 year.
I don't want to hear basically anything. I don't want to hear like anything. I don't want to hear generally anything. I just want to know the rule.
The rule is that the contract cannot be performed in 1 year and cannot be evidence in writing.
That's right. If it cannot be performed within 1 year, it must be evidenced in writing. What? What did I say? Cannot. If it cannot be performed within 1 year, it must be in writing. Okay? And how does one determine whether a contract can or cannot be performed within 1 year?
Based on verbally or writing that says how long it's going to take on the individuals, but it's not really stating it, an estimate to say normally done in a year. And then also normally cannot be done.
I'm sorry?
You will then look at the facts in the different contract.
Okay.
And then it will let you know, usually, that the estimated time, but if it does not have the time in there, you can then do an estimate for yourself to say that this was possibly done in a year or not.
Okay. And we all know what the bar examiners will try and trick you with when it comes to lifetime, right? So tell me how that is affected by the statute of frauds.
You really can't say lifetime because you can live, 10 years, 20 years, you don't really know how long it's going to be. And it says within 1 year, so you really wouldn't know.
So,
Possibility of completion, you also only live 1 more minute,
correct.
which would be shorter.
Okay. Employment until I die, that's going to be one that I guarantee you'll see at one point. And you'll say, I know this. No. Okay. If a contract that cannot be performed within 1 year allows both parties the right to terminate within a year, there is a split as to whether the right to terminate takes the contract out of the 1 year prong of the statute of frauds. The majority views that non-performance is not performance within 1 year, and so the contract is still within the statute of frauds. The minority, second restatement view suggests that because the contract is terminable by either party within a year, it is outside the statute, okay?
So what do we do with that?
If you see a situation like that, and the contract, or the fact pattern discusses that it is terminable by both parties, and you don't have a writing, or you have an incomplete writing, and you know for certain that it is a statute of frauds situation, if you remember it, bring it up. Okay? If Barbara teaches it to you again before your bar exam, then remember that there's a split. If it's terminable within 1 year, it's not. And some say that it is. Okay, so performance is not within 1 year, a promise that by its terms. So remember, the terms are what make it not be able to be performed within 1 year. The terms, as stated, whether the date is stated specifically and explicitly, or the terms would not permit that the completion be within 1 year.
So you and I agree that we're gonna sell oranges in the supermarket, to the supermarket. Okay, you and I can terminate our agreement at any time.
Well, number one, why is that covered under the statute of frauds? If we're gonna sell oranges
We're gonna sell-
366 days.
These are gold oranges. Solid gold.
Is that, are they, what, okay, solid gold oranges,
Or it's $4 million.
okay. So sale of goods for,
That would be covered under the reason.
yes, well, who has that? Who has sale of goods? Answer his question.
What was your question again?
Okay, I think I'm asking. We're gonna agree to sell oranges indefinitely in the supermarket.
Indefinitely, what does indefinitely mean?
No term.
Could that be performed within a year? Could we sell our oranges within a year? We're gonna just sell oranges
We're gonna sell
indefinitely?
All of the oranges that we have. To the supermarket.
Okay,
You and I can agree to terminate our agreement to do that. You and I agree.
mm-hmm,
There's 50 million oranges we get this year.
okay.
Sorry, this is.
No, I understand, and it's not
Understand.
conceivable, it's not conceivable, is what you're saying, to sell them all within 1 year.
But
Know what you're saying?
But I'm asking about, what I ask you about this agreement that you and I would terminate it.
Terminable at will.
Terminable at will. How does that affect the application of the statute of frauds?
Well, that's what the split is. This isn't a split that I knew of at the time that I took the bar, okay? So it's not something that I even remember learning about. It's something that I'm reading about now, when I'm reading it more in depth, which is great to know, and maybe I did know it at the time, but it's not something that is going to make or break your exam. Not understanding or knowing the 1 year rule might make or break your exam, because that's statute of fraud is very testable. But the terminable at will and the split of whether it remains in statute of frauds or whether it doesn't, is not gonna be a make or break situation.
If it does not, if the minority opinion says that it's not covered,
Then it's oral is fine.
then our oral agreement is enforceable.
It our oral agreement is enforceable, or an insufficient writing is enforceable. So remember, the statute of frauds doesn't just say a writing, but it has to cover, the essential terms. There has to be a writing. There are certain things that make it a writing and an enforceable writing, right? Like the signatures. So in your situation, somehow the minority applies, the restatement applies, second restatement applies, and because it's a terminable at will situation, it takes it out of the statute of frauds. Therefore, either A, the oral agreement is enforceable, or B, we have a writing, but it's an insufficient writing, which if it was under a statute of frauds, wouldn't be sufficient. Exactly.
But in this case,
Correct. Yes, correct.
The example you gave about lifetime employment, I don't understand that.
Why not?
I don't understand how the statute of frauds cannot apply to that.
Okay. I give you employment for your lifetime, or I'm giving you use, how about this? I'm giving you use of my car for your lifetime, or for my lifetime. The statute of frauds rule that would be triggered in that situation, because it's time, it's not a sale of goods, it's not marriage, it's not a suretyship, it's not an executor, would be contracts for a year or more. So you think automatically, okay, well, she's giving me use of her car for 1 year, or for my lifetime, she breached that, I no longer can use the car. Do I have a writing? Do you need a writing?
For statute of frauds, yes, we need written contract for all subjects that are involved.
Okay, so if I give you permission to use my car for your lifetime, and then I breach that promise, does that have to be in writing? To be in order for that
Yes.
agreement to be enforceable? Okay, tell me why.
Well, the statute of frauds, that's what it is.
Which rule would be triggered, number one?
Well,
Under my legs.
well, definitely not marriage.
Right.
Definitely not, well, I think the year, the promise to perform within or unable to perform within a year, maybe. Definitely not land. Executor?
No. Goods for $500 or more.
No. And sure, I can't say that.
Suretyship.
Suretyship.
Promising to pay the debt of another. No, so you're right. The only one that would be triggered would be the time, would be contracts that cannot be performed within a year. Now, tell me why this contract cannot conceivably be performed within a year. If I'm giving you my car to use for my lifetime or your lifetime.
Well, it's reasonable to believe that if you're allowing me to borrow your car for your lifetime or my lifetime, that means I have immediate access to the car.
That's correct. You're correct.
So that's being performed within.
It's not
a year.
being performed within 1 year. It cannot be performed within a year.
It's a lifetime.
See, that's what I don't understand. That's where my mind just is not.
It's confusing.
So it is enforceable because it can be performed.
Okay. Who, raise your hand if you're having the same difficulty. Me, I'm having difficulty. I was hoping somebody explained it to me. Who's having difficulty? This is not the class to be shy. You? You? Okay.
Can I try to explain it to you?
Yeah, of course, go for it.
What's wrong with that? Because it could be performed within a year, or she could fulfill her promise to you in a year.
Explain to her how she could, how it could be performed within
You
1 year.
can fully perform your promise credit cards for a lifetime. The next 4 days. God forbid you step out of the promise. She has been fully performed her contract, her promise to you.
Correct.
That was performed in less than a year. Short term. So, therefore, it can be enforceable.
It is enforceable.
It is enforceable
Without a writing.
without writing because we perform less than it cannot be unless if that's right.
I understand that if it's right, but I think it was right.
This is the other way of saying it. Oh, great. I'm gonna make a personal request that they jack up all of your tuition just like my markers.
Really, so.
Jeez Louise. Okay, I was gonna try to be creative and make the does not very emphatic, but oh well. We'll do caps, okay? Does not have to be in writing. I.e. not covered or is not covered under the statute of frauds. It is not part of the statute of frauds. Does that make sense?
Yes.
Not,
Can be performed under 1 year. It's enforceable.
i.e., yes, oral agreement,
Without it.
okay, or insufficient writing, okay. Still good, contract's good. That make sense?
Say insufficient writing.
So the insufficient writing, the essential terms aren't there. Because if you have a writing that cannot be performed within 1 year, and it is covered under the statute of frauds, you have to have a writing that is sufficient. For example, like a contract must have certain indefinite terms. Same thing, exact same thing. No judge wants to sit there and babysit you and try to figure out what terms you guys intended or wanted. Because then what are you going to have to do? You're going to have an evidentiary hearing and cross-examine who's being truthful, who's not. It's just a waste of everybody's time. Okay. Are we clear on the 1 year thing? So just remember, lifetime not guaranteed. Therefore, it might be under 365 days. Therefore, it is possible that it can be completed under 1 year. Therefore, never kind of covered under the statute of frauds. Okay. Should we move on? Should we do the case?
Lifetime contract is doing something.
Yep.
Short term.
Yeah.
Possible.
Yeah.
Sounds cool.
Exactly, and that's why it's testable, because it is your first your first reaction is, looking, duh, lifetime is longer than a year. Who had a question? Somebody had a hand.
I did. After the lifetime employment, it covered non-compete a little bit. I'm a little curious about that personally. It says a promise by seller of a business not to compete with the buyer for a period longer than a year is not within the 1-year provision. It says if the seller dies within a year, the buyer has received the equivalent of full performance. Parentheses, knows the seller won't be competing with it. Can you put that in the, I think I understand that. Please put that in a better terms for me, like my business.
Okay.
I buy it. Somebody, okay, so a promise by a seller. So I go to buy a bakery or a restaurant, and this seller decides, okay, I'm not going to compete with you for longer than a year. I'm not going to compete with you for 5 years, let's say. And it can be oral agreement, because it does not fall within the 1-year provision of the statute of frauds, which requires writing. Is that correct to assume? Or am I?
Because I don't know, during break, make me a copy of the page so I can read it. Okay? And then I'll dissect it. Is it break time?
Almost 3 minutes more.
3 minutes more. Okay. So we can go either straight to the case, do the case, and then you can break, or we can take a break right now. What? Hello?
Break first.
Okay. Can you please, is 5 minutes enough time? I think it is. 6:58. I gave you an extra minute. Go use your break. No, it's really, somebody's telling me, you don't give them breaks, you need to give them breaks. It's very important. Okay, your question. Seller promises not to compete for 5 years. Seller can die under a year. When seller dies, possibility of competing dies too. Seller therefore can complete performance under a year.
So it does not fall under the 1-year provision of the oral agreement?
Yeah, because he can die, and once you die, the possibility of competing. So it's full performance. If it was, let's say, payment, right? Because the competition is personal to the seller, right? But let's say it was payments for a debt, let's say, for a year or 5 years, installments. It probably would still have to be in writing. Why? Because the estate could pay. Versus the competition is personal to the seller. The seller dies, there's no more competition. Performance is complete. That would be my understanding. I don't know. It doesn't really say. He knows the seller. If the seller dies within a year, the buyer has received the equivalent of full performance. And then it says in parentheticals, he knows the seller won't be competing with him. That's why I don't like all these other things, because you can, for example, your business, right? You could be seller ABC company. Let's say the CEO dies. That doesn't mean ABC company isn't still competing with DCU company. So this doesn't really address the fact that you can have a non-compete clause, and one person dies doesn't mean the company is. You know what I mean? So I don't know how this would make sense in real terms. Because it's usually non-compete isn't usually just with one person. It's usually their enterprise.
Usually. But I can see a situation in which you would have an executive of the company moving to a different group or whatever that could be in direct competition with your company. And he was moving into that executive position and wanted to compete. Does that not fall under that, or would it be more of a non-disclosure? I've seen them bunched together, non-compete clauses and non-disclosure clauses. Really with an individual moving from executive position to another company's executive position or coming from.
They aren't really the same at all.
They're not, right?
They're not, but they both have the word non in front of them, so that makes them similar.
I mean, some of the sample agreements and civil stuff that you see online, not it's usually like non-competitive and non-disclosure agreement that they just want to, and I know for this class that those are.
Yeah, non-disclosure would be what Stormy Daniels did with Trump, and now she's in breach of it, and now they're gonna try and sue her for $1 million. And her attorney is saying that it's a completely void contract, the non-disclosure, because Trump didn't sign it, only his lawyer did. It's backwards, because she's the one being sued and she signed it. So why does Trump have to sign it? And on top of that, his agent signed it, his representative signed it. And it's probably, I mean, I don't know, but they probably just don't want to be in trouble for $1 million or whatever that is. But it's probably also not the best argument. Right? You guys would know that. Michael Visconti or whatever your name is, he doesn't know that person. Why, he needs to go back to contracts, one. Yeah. Yeah, but he's like really adamant on TV. He's like, this is an unenforceable agreement because Trump didn't sign it. Hey.
Stupid on national TV.
Yeah, so Trump's not the one getting sued on the non-disclosure. So why would he need to even sign it? Because he could take that agreement and sign it right then and there. We're like, here you go, signed it. Right?
Read that thing.
Okay, Crabtree?
Okay. All right.
What page is this?
302. Yep.
Is this Crabtree?
Crabtree v. Elizabeth Hardin Salesforce.
Is this Crabtree and Evelyn? At one store?
Hardin's appealing judgment from appellate division and affirmative judgment in New York Supreme Court in favor of Crabtree in a breach of contract action. Here, Crabtree entered into September 1947. Crabtree entered into preliminary negotiations with Elizabeth Arden Corporation as an employment for sales manager. He requested a 3-year contract, $25,000 a year, and he insisted upon an agreement for definite term. He repeated the desire for a 3-year contract with Ms. Elizabeth Arden, Corporation's president.
Who are these people?
Well, Arden is a defendant and Crabtree's a plaintiff.
I know that because I see where they are on the V, but why don't you tell me who they are?
Oh, Crabtree is a person that was looking for an employment as sales manager. Elizabeth Arden.
Okay.
Yeah.
Crabtree was looking for employment from Elizabeth Arden, defendant.
Yeah.
Okay.
Elizabeth Arden is the president of Elizabeth Arden Salesforce. Okay, when he met with Elizabeth Arden, the president, she indicated she was prepared to offer a 2-year contract, an annual salary of $20,000 for the first 6 months, $25,000 for the second 6 months, and $30,000 for the second year, plus expenses, $5,000 a year. Crabtree replied, "That's interesting." The offer was interesting.
Okay, why does that matter?
Well, it might be an assignment, or it might be an acceptance of some sort.
Well, why are you asking me?
I'm not asking, I'm just kind of stating the rhetorical question. Ms. Arden, therefore, upon her told her personal secretary to make a memorandum on the telephone blank, word blank. So it basically stated everything except she said 2 years.
Okay.
Okay. And it wasn't a sign, it was just a memo. A few days later, Crabtree phoned Mr. Johns, who's the manager, or executive vice president, general manager, and he accepted the invitation join the Arden organization, and Ms. Arden wired back her welcome, quote unquote. He reported to work on a payroll change how it was made out and initialed by Mr. Johns. That's the memo. The memo states $20,000 premium, per annum, $25,000 next 6 months, and $30,000 after 1 year of employment. And it was signed by Robert Johns, RPJ, he's initialed it. After the 6 months of employment, Crabtree received a scheduled increase from $20,000 to $25,000, but the further specified increase at the end of the year was not paid.
Okay.
And then, well, there was much to ado there. Johnson, the controller, said they would fix it, but Ms. Arden just said, I'm not gonna do it. I'm not gonna approve the increase. And basically the discussion was fruitless, so the defendant left. Crabtree left and commences action for breach of contract. When the trial started, Ms. Arden denied the existence of any agreement to employ the staff, employ Crabtree for 2 years. And then she said, even if it was made the statute of frauds part of enforcement, so she was defending the statute of frauds.
Okay, so why are we even talking about this case? What rule would it be covered under if we were to have this as a fact pattern in an exam? And the issue here is there was a potential breach. Plaintiff stopped paying her, paying plaintiff the agreed upon salary increase. And now defendant brings this cause of action for breach of contract, right? For the increase in salary.
Well, performance not within the age, she's arguing.
Okay, so,
After in the second year, he's going to be paid after a year, he's going to be $30,000.
okay, so which rule would this trigger under my legs?
Performance not within.
Great, wonderful. So we're starting there. This is covered under the statute of frauds, under contracts which cannot be performed within 1 year. And do you agree that this cannot be performed within 1 year?
Well, yeah, perform within a year, if he's going to be going through full employment.
Okay, well, this is a 3-year employment contract, so how can it be performed within a year if the time is stated as 3 years, right?
Right.
She dies or not dies, it's still 3 years, cannot be performed, meaning she can't work for 3 years under 1 year, right? Okay, so it's
That's
covered.
2 years.
Oh, okay,
He asked
sorry,
for three.
she asked for 3, plaintiff asked for 3, and they offered her 2 instead with different salary installments.
Right.
Okay, so then, what's the issue here?
The issue is, let's see, where's
So we talked about when it is covered under the statute of frauds, what you need then, right?
well, you need it, right?
Right, and what kind of writing do you need?
There's this multiple documents that constitute the signed writing.
And are they sufficient?
Well, in this case, could be in one, does it require one memorandum? Or can these documents signed and unsigned be voted?
Right.
Including oral.
So can you bring in all this evidence as proof of the sufficient memorandum and or document?
In this case, you can, because it's consistent with it.
Great.
It was consistent with it. The
Okay.
oral testimony is allowed because it was also not contradicted.
So usually when you have these evidentiary hearings, you can only do that when you have some evidence that's consistent with what you're actually stating. Okay, you don't just get evidentiary hearings to prove whatever it is that you want unless there's some backup. You gotta have backup. So what did the court say here? Why do we care about this case?
Well, the court went along with, here it is. The statute of frauds does not require a memorandum to be in one document. It may be pieced together out of separate writing, page 305.
Okay.
Separate writings connected to one another either expressly or by internal evidence of subject matter or.
It's the fourth paragraph down.
Fourth paragraph, I'm sorry, 1, 2, 3, be Codwin. I guess that's good, you guys, not what we're talking about.
Issues.
Okay, so here, the trial court was justified in finding a sufficient memo to satisfy the statute of frauds by linking the three documents together, okay? So it's not just that there's a writing, it has to be a sufficient writing.
That they are referred to consistent with the subject matter.
Yes, absolutely, 100%.
306,
The sound, obviously.
first paragraph.
So does it mention anything about the signatures of the parties?
Mm-hmm.
Oh,
Okay.
it does. One, two, third paragraph, the middle of the third paragraph. Starting with, all of them must be sent out. Let's see, 1, 2, 3, 4, 5, 6, 7, 8. Line 8, third paragraph.
On what page?
Page 306. For second full paragraph, line 8. All of them must be sent out in various writings presented to the court in at least one writing, and at least one writing of one established a contractual relationship between the parties must bear the signature of the party to be charged, while the unsigned document must, on its face, refer to the same transaction and set forth the limit charge. That goes
Okay.
into the parole.
This case mentions to some extent parole evidence, which we're gonna go into a little bit later, okay? I wanna really get through that.
Paragraph after that covers the parole evidence.
Well, did you understand it enough to tell this class what it is? Why don't you tell us what it is, what you got from the
Well-
parole evidence discussion?
Parole evidence requires that we are able to establish the connection between signed and unsigned. In other words, it has to be consistent with what is assigned writing. Otherwise, if it contradicts terms, it contradicts the contract in itself, the judge is not going to allow the admission.
Correct.
And then, well, that's about it.
It also has to be, what's the,
So when you think about statute of frauds, you may also be triggered to think about parole evidence. And the reason that you think about parole evidence when you think about statute of frauds is because the two require the same thing to even be remotely relevant, and that is not even a signature writing, a signed writing,
Signed.
a written contract. Both to be discussed you must start with the first question: is there a signed writing? Is there a written agreement? If the facts do not discuss a written agreement, don't ever bring in parole evidence. That is going to be that is a way to indicate to whomever is reading your exam that you have no clue what you are talking about.
Yeah, if the
If
facts don't
the
indicate.
facts do not indicate a written agreement, not a signed written agreement, not a sufficient written agreement, a written agreement, okay? You have no business ever bringing up the words parole evidence, okay? If you do,
It's a partially integrated.
a partially integrated agreement, well, a partially integrated agreement is still a written agreement. Integrated just means, is it complete or is it partially complete? You and I could enter into a contract with most of the terms, but not all of the terms. And I don't have that little clause at the bottom which says full and final integrated agreement. Therefore, you just argue it's a partially integrated agreement. Not all of our terms were in there. It doesn't mean it's not a writing. That's what partially integrated versus fully integrated means. And when you see four corners of the agreement, it means everything is there that's supposed to be there intended by the parties, yes?
Would it be plausible to say then, not plausible, could we then say any writing, any signed writing?
You can bring
You don't even have to go so far as saying a signed writing, because you go into the a written agreement. Because the signature could present an issue to whether it's a fully integrated or completely executed contract, but that's still could still be a parole evidence issue. If there's no writing, if there's no written agreement discussed, and your facts just give you oral agreement, oral discussions, then don't ever say the words parole evidence. That is, hello, I do not know what I'm talking about. Okay, that's that. Okay, so we understand that even though, so this is a 2-year contract, even though you have separate types of salary increases, it's still covered under the statute of frauds, and you can piece together a sufficient memorandum or sufficient writing with different pieces of different documents, okay?
In this case, the 2 years was the one that was questioned.
What's that?
Well, it
What's the
wasn't in the
question?
written memo. It was the 2 years that was missing. They took it from the evidence, parole.
Okay. Because if you don't have sufficient writing, and it is covered under the statute of frauds, the defendant here would have a defense to formation saying this is not an enforceable contract. But the judge allowed it in. The judge allowed in these piecemeal documents to make up a sufficient writing enough to satisfy the statute of frauds. So that's how you address it. When you discuss the statute of frauds, number one, the question would be, is this covered under the statute of frauds? That's going to be your first issue, okay? Number two, does this writing satisfy the statute of frauds? Is it A, covered? Is it B, satisfied? That's it. That's how you write it.
Just to clarify, is it satisfied, we're talking about certain definite terms?
Yes. Yes, for lack of a better, yeah.
Yes.
Sufficient writing is basically certain indefinite terms, i.e. essential terms. Are the essential terms covered and was signed? Questions? So can everyone remember that? When you discuss statute of frauds and you kind of don't know how to put it down on your exam, and there's a writing, and you know it's my legs is one of those, okay? And you're like, how do I write this? What do I do? Your first question is this covered under or does this fall within, okay? Same thing, okay? Then 2 would be, does this writing satisfy the statute of frauds? Yes, then you're good and it's enforceable. No, then it's not enforceable because you don't have a sufficient writing. Okay? Satisfied means sufficient writing, meaning the essential terms are there, it's signed, etc., etc. So this case that you just covered was this issue. Does the writing satisfy the statute of frauds? Because they said yes, because obviously it's a 2-year contract. So yes, we know this is covered in the statute of frauds. Then you go to the next one. Okay, now is it satisfied? Does it satisfy the statute of frauds requirements, which are the essential terms? And here it did. Therefore, this lady wins, or Crabtree wins, right?
Crabtree.
Right, plaintiff won, so she gets her pay increase or whatever.
Well, no, he got 14 grand in damages.
Okay, so she got damages. She got the money. Questions? Very simple, right? That's how you address everything. Is it satisfied? And is it covered? It's just like, what law is applicable? And you just answer the questions. What's next? exceptions. Well, we have statute of frauds part performance. So why does that matter? That's Jackie, but she's not here. The next case is part performance, Beaver B. Brumlow. Oh, she just got here. Did you brief your case? Beaver B. Brumlow? Your entire class is waiting with bated breath to learn about part performance and statute of frauds.
We were doing, that. Let's listen to that.
Landon v. Alumni?
Yes, you're gonna do land.
Where's statute of frauds?
Who knows when we take the contracts which would otherwise be covered under the statute of frauds, when we take it out of the statute of frauds?
Exceptions.
Yes,
There's partial performance.
partial performance.
The exceptions to essential ones.
Mm-hmm.
When there's partial performance,
Okay,
when they started performance, even though it wouldn't have, even though it needed a writing. Yeah, even though it needed a writing, if there was partial performance and there was no writing, then it would be, it would come out of the statute of frauds.
are you sure that partial performance takes it out?
Partial performance.
If you could find me that rule, that would be really great.
Complete performance.
Hmm?
There's complete performance.
If, for example, you leave your, buying a parcel of land and, for whatever reason, there was no writing for the purchase of land, and you gave me the keys and said, okay, Jackie, in 10 days, you can give me the money, for the down payment, and we can take, control of the land. If I went in there and started painting, started renovating, even though there was no writing, and the other party decided to say, well, you know, I don't want to sell the land to you after all.
So,
Specific.
well, okay. So, two things. Situations in which the contract is removed from the statute of frauds. Land sale contracts. If the seller conveys to the buyer, i.e. fully performs, he can enforce the buyer's oral promise to pay. Likewise, the buyer may seek to specifically enforce an oral land sale contract under the doctrine of part performance. Part performance that unequivocally indicates that the parties have contracted for the sale of land takes the contract out of the statute of frauds. What constitutes sufficient part performance varies among jurisdictions. Most require at least two of the following. Number one, payment in whole or part, and two, possession and or valuable improvements. Okay? So in relation to land sale contracts, part performance does take a contract that would otherwise be required under land sale contracts out of statute of frauds, okay? That is on page 46, section 5, or number 5, 5A1, okay? 46 in Barbary is what gives you the list. 45 is when writings are not required. This is all under the statute of frauds, and 43 is 43, 42, 41 is where, so 41 through 46 is generally where you can read about the general statute of fraud rules as well as the exceptions, okay? So we have, did you do 315? Reverse Brumlow, it's actually what you just covered, part performance.
I know I read.
Here, let's read 312, section 5, also in our casebook, section 5, exceptions to the statute of frauds. We have already, here, actually, I'm going to have you skip down to 313. I want you to read, mark in your book, section 5, 312, read 312 to 313, and then I will read reliance-based exceptions to the statute of frauds, okay, and then we'll go on to the case. These exceptions have in common that the breached against party has in some way relied upon a contract unenforceable because it is not set forth in a signed writing that satisfies the statute of frauds, okay? So that's how it works. There's a breach, and then they can't get recovery because the contract is unenforceable because it doesn't satisfy statute of frauds. Their exact contours vary greatly. However, because reliance may clash with other parts of the law, restitution and equitable remedies most importantly. We will therefore go through each part or full performance and preparation to perform in order to determine how these legal doctrines have shaped each exception. The part performance exception, which Jackie was just talking about on page 313. The exceptions based on performance vary tremendously based on the particular provision of the statute of frauds that is relevant. For example, these exceptions do not exist for contracts with the suretyship provision. Partial performance may satisfy the evidentiary aspect of the suretyship provision, but it does not satisfy the cautionary aspect nearly as well as does a writing. Moreover, a party does not ordinarily seek to enforce a surety contract until a party's performance is complete. So allowing this exception would gut the suretyship provision. On the other hand, there's full performance exception to the 1-year provision. Restatement 130. Partial performance does not suffice because the 1-year provision generally becomes relevant only after performance has begun. Why full performance is an exception to the 1-year provision is difficult to explain, except perhaps as a way to avoid the messy valuation problems that would arise in restitution. I want you to read the next paragraph, the 2 provisions most affected. That's in the middle page of 314. I will continue on, starting with the most important use. The most important use of the part performance doctrine comes in contracts for the sale of interest in real property or land. Often the seller lets a buyer start improving the property under contract even before title has passed, which can create a problem if the seller thinks better of the deal. On the other side, a buyer who has started paying for the property presumably does not do so out of the desire to make the owner a handsome gift. Part performance is an exception to the land sale. Land contract statute of frauds differs materially from its Article 2 counterpart. For largely historical reasons, this exception applies only when the breached against party seeks specific performance of the contract. It also requires reliance expressly, not just as the basis for the other elements of the test. The court often uses a heightened evidentiary standard. Clear and convincing evidence is common. Finally, specific performance is a drastic remedy, so it is available only when there are no reasonable alternatives. If the contract itself is not enforceable, the main alternative is restitution. Even though restitution may not be entirely compensatory, it nevertheless is usually considered adequate. There are 2 key issues in part performance litigation under the land contract provision of the statute of frauds. First, is the putative performance actually performance of the contract at issue, or is it consistent with another type of contract? For example, merely making monthly payments on the property one occupies is consistent with both a purchase and a lease, and consequently is not unequivocally referable to the contract. Second, if there has been partial performance, it is both possible and necessary to give an equitable remedy. Or should the breached against party be relegated to restitution? Both issues are addressed in the following decision. Who's going to brief Beaver v. Brumlow?
I'm gonna take it.
Great.
So, Beaver v. Promo. Mr. and Mrs. Beaver had some land that they had offered at one point to sell to Mr. and Mrs. Promo, who happened to also be in the employ of the Beavers. Over the course of 3 years, the Brumlows made improvements to this land, although there never got to be an actual written contract for the sale. The Beavers drove past the land on a daily basis. They were aware of the improvements. They knew that the improvements were going on, and at this point in the relationship, were supporting the eventual sale of the land to the Beavers. I'm sorry, to the Brumlows. In 2004, the relationship changed, however, when Mr. Brumlow gave Mr. Beaver a 2-week notice and left his employ. At that point, the relationship soured, and Mr. Beaver no longer wanted to sell the land to the Brumlows. So they attempted to restructure all of the 3 years worth of negotiations into kind of a lease arrangement. At which point they started charging the Beavers a $400 a month payment, or a $400 a month charge, which the Beavers represented was a lease payment. The Brumlows represented it as payment for the land. All comes down to court. The Brumlows argue that even though there isn't a written contract for the sale of land, there should be a sale here. The Beavers used the statute of frauds as a defense and said, hey, listen, this is a land contract, and therefore, since it wasn't written down, it's not there. The first court comes to the conclusion from all the ancillary evidence, hey, really there was supposed to be a land sale here. Everybody acted in such a way as if the land sale was imminent. We believe the land sale was the intent, and they gave the Brumlows the choice of either enforcing specific performance of the contract or a cash damage. And the Brumlows actually chose the specific performance. They took the land, sending over a check for $10,000.
Okay, so just for some of us that may not remember what specific performance is, what is specific performance?
Either enforce the exact terms of the contract or accept a cash alternative.
Okay.
And in this case, it was the specific terms of the contract were turn over the deed to the land.
Okay, so, no formal sale documents were prepared because the sellers learned that their mortgage contained a due on sale clause that required the entire amount to be paid when the land was sold. When the buyers consistently requested that the contract of the sale be formalized, they were told, quote, "we will work it out" by the sellers. Is that correct? Although a date was never mentioned for the sale of the property and a price was never determined, the buyers had stated that they would pay the market price for the land. After leaving the employment of the Beavers and working for a competitor, which I think is what created the problem, the relationship, like you said, deteriorated. The sellers then changed their mind, and the buyers brought suit. The sellers, Beaver, brought suit to alleged that, or argued that the statute of fraud barred enforcement because this agreement, the putative agreement was covered under the statute of frauds because it's a land sale contract. And therefore the contract was barred by the statute of frauds and therefore unenforceable, right? That would be the first step. The trial court then disagreed, ordered specific performance. The sellers then appealed. Okay. What restatement section was used or applied here to determine whether or not this was going to be an enforceable agreement?
The first one, the first trial court decision or the appellate court decision?
The appellate court, I believe, is who applied it. Let's see.
And that was,
And take us to the different rules of law that we care about in this case.
okay. So in the appellate court, they came back with three particular areas that they were pointing to. Well, first was partial performance. Even though for land there's a requirement of writing, in this case there wasn't. The partial performance of the parties involved in it was as if there was a written document. Everybody was acting and behaving as if there was a written document. The second section that they hung on to the sufficiency of the verbal agreement right there in the middle of 319. And again, because people were performing in such a way as that there was a written document, the fact that there was an oral agreement was kind of this additional supporting evidence that a written intent or an intent to sell the land was in position, in place. And then the third thing that they touched on, which is on 321, the adequacy of the remedy, was more specifically to the fact that the Brumwells pushed for specific performance as opposed to taking the cash option. It was, they argued that it was an appropriate alternative available to them.
Okay, so look at or jot down, if you don't have your book for some reason, on page 317, under part performance, it states as follows. Where an oral contract not enforceable under the statute of frauds, which means it would be covered under the statute of frauds, has been performed to such an extent as to make it inequitable to deny effect thereto, equity may consider the contract as removed from the operation of the statute of frauds and decree specific performance. Okay? Next, page 318. A court of equity therefore requires that a part performance relied on to take the case out of the statute of frauds should be of a character not only consistent with the reasonable presumption that was done on the faith of such contract, but that it would be unreasonable to presume that it was done on any other theory. Didn't they do, if you had to address all the facts in which that would support part performance, what would those be?
At the very least, the fact that Mrs. Brumlow cashed in her IRA and 401k retirement savings and put in $85,000 worth of land improvements.
They placed their mobile home on the proposed property, spent approximately $85,000 making improvements. Okay, so, I moved in. Okay, so took took possession of the property by bringing their mobile home onto the land, made substantial improvements by skirting the mobile home, adding a septic tank and landscaping, okay? Do we have any questions as to why either A, this is covered under the statute of frauds, or why B, it satisfies the statute of frauds exception? Yes.
Like, again, what they were saying, like, they were taking into consideration what everything had done over here for consider, like, a formal contract. But I thought in order for it to be valid, the sexual contract still had to be.
That's correct. Well,
That's the part that I didn't get, like, I listened to.
which part, what part didn't you get? That there's an exception? So the first step is, right, these are the questions you want to ask yourself. So I think sometimes we're like, well, what do I even start with? Is a writing required? If my legs, yes,
Enforceable with the writing requirement.
yeah. Didn't that work just like 2 seconds ago? What's this one? To be enforceable contract, okay, is a writing required. When it falls under my legs, the first answer is yes, okay? And 2. Is there a right? I don't think you would have to ask yourself any other question than the ones that I'm about to write on the board, okay? Is there a writing? Assuming that there is, yes. What's the next question I'm gonna write? Before that. Okay?
So, is what's written saying what would make it a statute of frauds?
I'm sorry?
When you say, does the writing satisfy statute of frauds? In this case, does the writing talk about sale?
No. This is essential terms. Okay? Now, we'll just do 2B, right? Let's pretend that the answer was no. Is there writing? No. If there's no writing, what's the rest of this question? There you go. Got it? 3 and 2B don't go together.
There's an exception, maybe enforcement.
Correct. If there's an exception, then it was taken out of the statute of frauds by part performance, and it's gonna be an enforceable contract like we had here, right? This one was enforceable? So it's just this. My writing is so messy. Do you want me to just, I mean, think about it, you don't need to write this down, because you understand it. So, is this covered under the statute of frauds, i.e., is a writing required for this to be enforceable? That's your first question. 2, what's the next obvious question? Is there a writing? Okay, great, there's a writing. Next question, does the writing satisfy the statute of frauds with all the essential terms, writing, etc., signature, etc.? Yes. Great. You're good. And it's enforceable. However, what if there's no writing? Then either A, ask yourself, is there an exception to make it enforceable? Or B, no, it doesn't fall under exception, therefore your contract is unenforceable. Because you don't have a writing and there's no exception. Yeah, question.
403, does the writing satisfy statute of frauds essential terms? We also have to consider whether there's signature, right? Letter
Yeah, that would be-
Or that would be part of.
Yeah, so if I'm trying to sue you, or I'm being sued on this putative contract, or this alleged contract, the first thing I'm gonna look for is if my signature is on it. I have a contract with somebody that I'm disputing, and guess what? I never signed it. And they're trying to enforce it. You didn't make sure that I signed this contract, therefore you cannot enforce this against me.
This is just for.
Unless there's.
That's a problem. That's a real problem, and I've actually thought of that. Well, then what happens? I'm gonna say, prove, number one, I'm gonna bring, I'm gonna request an evidentiary hearing that,
Like a moment.
well, it would become an evidentiary hearing, and I would have them compare it to my signature, and then it would just be based on pure credibility. It would be pure credibility, because if they somehow provided my signature all of a sudden on this contract, number one, I would have to prove that, because you can, if they have other signatures of mine, they can just, right, forge it, or just compare it and say, look, that can't possibly be my writing, and you get a forensic analysis, or a handwriting analysis. But yeah, so it's not like that's a novel problem, those are dealt with all the time, I'm sure. If the basis for the ability to sue is a signature or not signature, you would think somebody would be crafty enough to forge a signature, especially if you have a lot of money on the line.
But admission in court,
Admission in court?
yes, that oral agreement did exist, you just said, solidify it in writing.
Yeah, you could, but you would have to get to that, be able to even get to that stage, because, so, if you think of a lawsuit, you don't just file your lawsuit and go to trial, okay? So you have so many stages, and in your first stage, you would be able to file a state equivalent of a motion to dismiss. And why wouldn't that be the first thing that you would address when you respond to a complaint? There's no writing. There's either A, there's no writing, or B, there is a writing, but my signature's not on it, therefore they can't sue me on it.
How would you get it?
So you get it dismissed off by motion. And the judge has no reason to,
How do you get to the point where they have you to admit whether or not it's a state?
you mean, so.
Because they're gonna dismiss it based on the motion because there is no writing.
There's no writing or it's insufficient.
But I'm insistent, there was.
I don't care if
there
you're
was a
insistent,
contract.
the judge
How do we
dismissed your lawsuit against me because I didn't sign the contract that you're trying to sue me upon.
Right, but how do you get to the point where the court can make you admit or deny it whether or not?
The judge would have to deny my demur, and then the case would move forward.
And is it common to see that?
For something like, I would hope that an attorney, this happens, but if I were to be suing an individual or a corporation on behalf of, for breach of contract, okay? One of the first things that I would look at is, did they sign it? If they didn't sign it, I would have to look for other reasons in which a judge would find that this contract did exist, even though there's not a sufficient writing, and it would be the exceptions. Like, we acted on our conduct was indicative of a contract.
Number 3. Maybe the answer is no. There's number 3, is there an exception?
To essential terms? Well,
There's a writing, it's not as satisfying. Then you're asking us to do an exception.
yeah, it would be the same, because remember, if it doesn't satisfy the statute of frauds, it's either A, because there's no writing, meaning it was just oral, or B, it's in insufficient writing. Either way, it doesn't satisfy the statute of frauds. However, if one of the exceptions applies, then you can circumvent that. Like performance, indicative of a contract. And to avoid inequity, the judge is going to, or the court is going to enforce the contract. Everything falls back to equity and fairness. So the more evidence you have that that this contract or this contractual agreement existed, the better off you were going to be avoiding the unenforceability because of statute of frauds. If statute of frauds presents a problem, just hope you have a bunch of other things to help support your argument that this contract existed. Okay? And you're going to see, you're just going to start wanting to do everything in writing. Because you don't even, it's so often that people are like, well, he said this and this happened, and I'm like, well, okay, can you show me? And then you have to be inventive and creative. It happens, it's really fun. That's what's really fun about lawyering, is you have to be a little creative. Okay.
I have a question.
Yeah.
So for the, number 3 again, can you check whether there's such essential terms?
Yeah, I can tell you where to look in your book.
What was that?
I can tell you where to look in the book,
No, I'm not.
in the Barbary, about the essential terms.
No, I was gonna ask if they only indicate in the writing only partial,
Meaning not fully the essential
only
terms.
part
are
of the
on there?
terms? If they only indicate only part of the terms, only those that are indicated are enforceable, right? Not the ones that are left out?
So you either are gonna have an enforceable contract or you're not.
So like, if
Yeah.
the contract was for, because I think there's an example in there of selling like 10 widgets, but then in the writing it only says 5 widgets. So only those 5 widgets would be enforceable, right?
Let me just read this, okay? Because I didn't read it before. 41 in Barbary. If a writing does not contain the essential terms of the agreement, it does not satisfy the statute of frauds and cannot be enforced. Meaning the contract in its entirety cannot be enforced. Because remember, if the statute of frauds is covered, or if this is covered under the statute of frauds, and then the writing does not satisfy the statute of frauds, the contract is not enforceable. And let's remember why we're even discussing the statute of frauds. It is a defense to what? Right, formation. So if you don't have a valid offer in a contract, what do you have? You have no contract. That's the exact same thing that you have here. If you don't have a writing, once you determine that a contract requires a writing, you have no contract. Nothing else special about it. Just it's like you don't have a contract. Okay? There's no definitive list of essential terms. They vary depending on the situation. What is essential depends on the agreement. There must be enough in the writing to enable a court to enforce the contract. If an element is contained in the writing, evidence is admissible to explain the particulars. If, however, a term is missing and cannot be supplied by implication or a rule of law, evidence will not be admitted to add it. The essential terms normally include the identity of the parties, the description of the subject matter, and the terms necessary to make the contract definite. For example, writings evidencing land sale contracts must contain description of the land and the price, and for those employment contracts must state the length of employment. For sale of goods, UCC requires quantity, and that a contract has been made, okay? So if it can't be supplied by evidence or by implication, it won't come in. Or it won't satisfy the statute of frauds, depending on how material it is, okay? Can we move on? We're definitely not getting through our cases today. Does anybody have questions? Okay. We're going to skip down to, okay, David, Diane, just give me the time, okay? Mental incapacity, we'll get to that. Just remember your cases, we're gonna get back to that, so go back, okay? I wanna start, I want to start with parole evidence, and I'm going to start teaching you about it right now so you can understand the reading, okay? So let me just cover with you what I want to have for next week. And I'll send you a follow-up email tonight or tomorrow with all of the cases who they're assigned to and what we need to cover. Okay, so parole evidence, what is it?
Evidence from outside what's within the four corners of the contract. And to clarify, answer or contradict what's in the contract.
Okay, that's a good attempt. Okay. So there are going to be very specific phrases and words which you must know, okay, for the rule of parole evidence. And basically it's going to say this, and then you're not allowed to say basically, only I am, because I'm doing it for purposes of summarizing what I will put down as a black letter law for you on the board. This is what the rule tells you. Any evidence, any outside evidence, any extrinsic evidence which intends to contradict or modify the terms of the written agreement are barred by parole evidence. Okay? Parole evidence is actually a rule of evidence. Okay? If there is information, number one, what was my number one rule in regards to parole evidence? And when do you never talk about it? Unless you have what? Okay. So, you are going to have a fact pattern and you are going to have a writing. You are going to have terms and it's going to be signed. Okay? So we have a writing, and this is we're going to consider this a chronological order, okay? So this is April 2. The contract was dated March 31, okay? Here we have March 30th, and March 29th, etc., etc. What parole evidence tells you is any evidence that somebody tries to introduce, which happened here, here, or here, or before, does not come in if its intention is to contradict or modify the terms which are stated in this written agreement. Parole evidence does not and is not relevant for introduction of evidence after the signed agreement. So today, okay? It's not an issue. It's anything that is evidencing or intending to evidence prior or contemporaneous information. Prior to means what? Before the executed contract. What does contemporaneous mean? Right, at the time. So March 31st or before. Okay? So if I intend, so let's say we have a written agreement for a car, a sale of car. Okay? And we have all the terms, and it says full and final agreement. Okay? If I intend to bring in evidence, first there'd have to be a breach or an alleged breach. And the purpose of the parole evidence, or let me actually back up. We have a written agreement, and I'm intending to introduce information which demonstrates that there is a breach of this contract. Okay? The way that I'm going to demonstrate that there is a breach by you of this written agreement is by bringing in evidence of prior or contemporaneous information. That could be our discussions, emails, anything, phone calls, anything. Whatever I have to evidence that there are some terms that are different from or contradictory to what is stated here and what is being breached. Parole evidence says you are barred from bringing that in. You are barred by parole evidence. You're restricted. Yes, but I'm going to give you the entire rule. But I'm just trying to make sure that you understand it, and then once I put the black letter law on the board, you'll actually understand it fully.
I'm sorry, is the full and final mandatory to kick off this parole evidence thing? If the agreement doesn't say full and final?
Okay, so when discussing parole evidence, so best case scenario, if you and I have a contract, okay, we have a written contract, and I'm executing the contract, I'm performing under the contract, and you tell me that I am doing something in breach of the contract. And I'm like, no, I'm not. Look at the terms. I'm doing everything according to the contract. And you say, well, you're in breach.
Remember, we had that email conversation.
We had an email discussion back and forth on March 29th. You then called me on March 30th. We discussed it, and you agreed. And therefore, you're not abiding by the terms of our contract. And I'm like, well, you know what? You're out of luck, because we have a fully integrated agreement, and it says full and final agreement. Therefore, that term that we discussed on the phone on March 30th should have been in there if you intended it to be in there. Yeah.
Sorry to interrupt. How much weight does it carry that the plaintiff says, or the defendant says, we have full and final agreement, which you also signed?
Which part?
It's the contract that says full and final.
Right, so full and final agreement, but he also signed it. So, wouldn't that be an
No,
argument?
no, no. He's not disputing the existence of the contract, and neither am I. I'm trying to bring in evidence that there's more to this contract or terms which are contradictory based upon our prior negotiations. And now we're disputing what's in here and what's actually intended. So that's why you're barred, because you're stating everything that is in this written agreement was the intention of the parties to be in this agreement, and there is nothing else outside of these four corners that was intended to be in here, and therefore anything else is out. It's a moot point, because if we intended it, it would have been in here. Especially, so the reason I bring up full and final expression agreement clause is because contracts put that in there so that if anyone tries to say, hey, you're not performing according to the terms, and I have proof of our negotiations prior to our execution, the full and final expression clause is an extra guarantee that you are completely, anything else is going to be barred from coming in. This, without being in here, you can argue that it's only a what, Mr. Fellows? You talked about it earlier. Or no, you did, Mr. Dean. What did you ask about? Partially integrated contract. And guess what happens with a partially integrated contract? You can argue that it's not a full and final expression of our intention, and therefore, all of that other garbage that I'm trying to bring in, our prior emails, our discussions, that may come in, because it's not a full and final expression of our intentions. Yes?
Can I, help me understand, can I write an example? Say another, it's an example.
You want to write an example? You can write an example.
This is how it's
You can delete all this.
No, it's within this, within your structure. So email, it says every 5, you'll get one free at $25.
Okay.
Here, it says 5 for $20. And this is, wow, what are we writing?
Full and final.
Full and final.
So, this email on this date exists. And you don't dispute that it exists? Contract says full and final, so you're as well. Contract says full and final, so that free one that you said that you give to me is not enforceable.
Yeah, but it only becomes an issue when you start telling me that I'm breaching the contract.
Breach the contract.
And then you say, well, you wrote me an email on March 29th that says, and I go, is it in the contract? No. And guess what? We have a full and final expression clause, therefore, what judge is going to say that that comes in? Our intentions are all right here. We're like in a closed little box and nothing else is going to come in.
Even though it's written.
I don't care because it's not in here. This is a final expression of our intention, and that's how you have to consider it. A contract which is fully executed is the full expression of the intention of the parties, and anything prior to or contemporaneous which intends to contradict, modify, or vary the terms of the written agreement does not come in.
Full and final is not there.
You'd have a better argument that it's not a full expression of our intention, and it was a work in progress. That's my term, but I'm just trying to help you understand that it's a work in progress, and you have a better chance of getting it in and not being barred by parole evidence. Yes.
So, just because I love being a pain in the ass.
Yeah.
Now, on April 1st, he sends you an email back saying, hey, what about my 5+1 deal? And you actually turn around and go, oh, geez, I forgot about it, and email back. So it's now post full and final contract.
Okay. that is not barred by parole evidence. And it is, because why? Hold on, but why? Well, first of all, it falls under one of the exceptions.
I thought you could use it for any subsequent conditions and modifications.
So, what did I say about parole evidence in the chronology? Why do I have this on here? Prior and contemporaneous, which what? Seek to do what? Contradict, vary, or modify the terms of the what? Written agreement. So it can be written or oral, extrinsic evidence, seeking, which are being barred. It's not just oral. And a lot of the rules will say any oral extrinsic evidence which seeks to made prior to or contemporaneous to the written agreement, which is seeking to modify, vary, or contradict the terms of the written agreement, are barred by parole evidence. But it's actually oral or written extrinsic evidence. What does extrinsic mean? Outside. It means outside. Okay, but we only care about extrinsic evidence prior to or contemporaneous, meaning like stuff that was going on at the time that you guys were executing the contract but didn't actually get in the contract, and stuff before the contract. You know, because there's tons that happens weeks, months, maybe years before a contract is executed, right? But the contract should be the full expression of your intentions. Yeah.
I just want to see where myself. The one way that you say that within the contract that a person says, well, the agreement is the way it is, it's the full expression, say, of the contract. And then he said, I told you in the agreement, one gentleman said you were going to get 3%. And then the other one wanted to bring in new information saying that he wanted 6%. He agreed to 6% even though it's not there. Then you can say, well, you're trying to modify it, you're trying to change it, so it's not acceptable. But if then you have an agreement and...
Wait, what do you mean by it's not acceptable?
Because he's changing and modifying the information.
Okay, so it's barred by parole evidence. We must learn to speak in the terminology that we have to. Because putting in an exam is not acceptable, will confuse you and confuse the grader. So it will be barred by parole evidence, yes.
Okay, and the other...
Can you add something to what she's saying? Not yet? Okay.
And then, but if you had one where they have an agreement, and let's say this one that I saw, it said about chickens. One said that they're roasting chicken in different type of chicken, and the other one said that they want it. That you can bring in as I
Well, that's not barred by parole evidence. Why? I think I know what you're talking about, but why? Or, yes. So what do I love to discuss? There's the general rule, which you're learning now. Right. Then you graduate onto exceptions. And there are exceptions to parole evidence. So when will certain things that would otherwise be barred come in? Yeah.
I was going to ask, can you use parole evidence as a defense against enforceability of a fully integrated contract? So what does that look like? Like what, in your experience? Like what would...
I've actually used parole evidence in a lawsuit before, where, yeah, I was suing, but then I also became, not me personally, my client, we were suing on a contract, and the defendant then cross-complained against us and alleged that certain things were promised. They alleged fraud, and that certain things were promised, and our promises were made to induce their return promise, and those things were not contained in the written agreement, the working document, which we had. Yeah, and my argument was everything that you're alleging to support your claim of fraud is, well, not in regards to fraud, but everything they were alleging that we promised is barred by parole evidence. Because it would be in the contract, right? It would be in the contract. If you promised it, it should be in the contract. Now, there's an exception to parole evidence, and that is to demonstrate fraud. Okay? Demonstrate fraud, explain away a mistake is another one, and ambiguity. Now, why aren't those covered by parole evidence? Because you're not trying to contradict, you're not trying to vary, you're not trying to modify, you're trying to demonstrate fraud. You're trying to show that there's some ambiguous word in the contract, like chicken. Is it a roasting chicken? Is it a, what are the kinds of chickens? Frying chicken, you read that case, okay. All different types of chickens. Okay? I like my chickens fried and in a bucket. I do, I'm serious. Okay. Whatever that kind of chicken is. So, yes. So you would not be barred by parole evidence if it was for the purpose of explaining away an ambiguity or to demonstrate that there was fraud in the inducement, fraud in the factum, all of that stuff, okay? So this really serves a very good purpose. How could you have a contract, a written contract, fully executed, and now somebody's attempting to make the argument that there are terms in there that are different from the terms that are written, and that's really the reason for having parole evidence. It makes perfect sense. Okay. So should I write the black letter rule up on the board? Since you were all visual learners. I want you to be able to write this rule down by next week. And the way to do that is understanding it, because it's so easy. Because I have not written this rule down in my top contracts one last summer. It's so easy when you remember it, or when you understand it. Let me just talk about it with you. Any oral, and we can make this shorter, so long as it's comprehensive and includes everything that you need to have in it. We can make it shorter. Okay? I don't care. Any any oral or written extrinsic evidence, okay, is the first part, made prior to or contemporaneous with. This is a big deal. Do not ever say contemporaneous to or contemporaneous in, it's contemporaneous with. The full and final written agreement which seeks or seeking to contradict, modify, or vary the terms of the writing is barred by parole evidence. Let me see if I got that right. Okay. Okay. In interpreting and enforcing a contract, questions often arise as to whether the written instrument is the complete embodiment of the party's intention. Where the parties to a contract express their agreement in a writing with the intent that it embody the final expression of their bargain, the writing is an integration, okay? The integration can be either what? Partial. Or full, yes, full, total, complete, or partial, okay? And those are important to know the distinction because one, well, you'll have a better time arguing that you're not barred over the other. Any other expressions, written or oral, this is the rule in Barbary. Any other expressions, written or oral, made prior to the writing, as well as any oral expressions contemporaneous with. If you look at Barbary, anytime that you see bold, italicized words, those are the ones you have to know, okay? As well as any oral expressions contemporaneous with the writing are inadmissible to vary the terms of the writing, otherwise known as barred by parole evidence, i.e. inadmissible. So it's evidence that you're attempting to bring in, okay? The oral or written extrinsic evidence is evidence. It can be in the form of, it can be in the form of emails. It can be in the form of testimony that you want to give as to what was said. And if your intention is to contradict, modify, or vary the terms of writing, I'm sorry that you feel that they're breaching the contract, but your proof doesn't come in. Okay?
In order to use this, it has to be a valid contract to begin with, right? Correct.
Very good question. Very good question. Yeah. You have to have a valid contract to begin with. Yeah. So let me read you a little example. Oh, it's already 8:30.
What? You were having fun?
Okay, before I move
Fried chicken?
forward, I love fried chicken. I made chicken with almond flour once. That was really good.
And we digress.
When I'm not thinking about contracts, I'm pretty much thinking about food. Yeah, it's sad. Buyer is interested in purchasing a new car from dealer. He settles on a particular car, and buyer and dealer.
Sorry.
Okay, let me start. Dealer tells buyer that if he agrees to buy the car today, dealer will provide free car washes for as long as buyer owns the car. The two parties finally come to an agreement on price and sign a written contract. The written contract contains a clause providing that it is the full agreement between the parties. However, it does not provide for what?
Car wash.
Free car washes. Absent an applicable exception, the parole evidence rule would prevent buyer from introducing evidence in court of the oral agreement concerning car washing services that were made prior to the execution of the written contract. So, let's say the buyer wants to now, he comes with his Toyota Corolla to get his free car washes from the Toyota dealership, and they're like, that's not in here, I don't know what you're talking about, and so he sues Toyota for breach of contract. Car washes are expensive. I do the cheap ones, but if you do the full ones, they're really expensive. Okay, so he sues them, and it's for as long as he owns the car. Let's say he has a 3-year lease. That's a lot of car washes. That's a lot of money. So he sues him for the car washes or the value of the car washes. And the first thing that's going to happen is they're going to move to dismiss based upon the fact that that's based on parole evidence. Sorry, you're barred by parole evidence to even introduce the prior negotiations because it's not in the final written agreement. So it's not even going to get anywhere past the initial pleading. It's going to be dropped very quickly. Okay? Purpose. In its name notwithstanding, the parole evidence rule is not generally, it's not generally, it says it's not general, I learned it was, regarded as rule evidence, but rather a rule of substantive contract law. It is designed to carry out the apparent intention of the parties and to facilitate judicial interpretation by having a single, clean source of proof, the writing on the terms of the bargain. Okay, that makes sense. Is the writing an integration? Okay, so this is important because the first step in, once you determine that you have a writing, the second question you're going to ask yourself is this a fully integrated contract? When it is a fully integrated contract, you're going to have an easier time barring evidence, prior or contemporaneous evidence, or you're going to have a more difficult time bringing in evidence when it's a fully integrated, depending on which side you're on. So that's the first question you're going to write. Or you're going to ask yourself, is the writing intended as a final expression? And why do we care about whether or not there's a fully integrated clause? The fully integrated clause is evidence that it was a final expression. It's just further proof that this was intended to be the final expression of the parties, okay? Or is the writing a complete or partial integration? Okay. Is the writing a final expression? Writings that evidence a purported contract are not necessarily the final expression of the contract. Thus, for example, the parties might have only intended such writings to be a preliminary to a final draft. If so, the parole evidence rule will not bar introduction of further evidence, okay? Any relevant evidence is admissible to show that the parties did not intend the writing to be final. Note that the more complete the agreement appears to be on its face, the more likely that it was intended as an integration. That's the purpose behind this is a full and final integration, or full and final, the full and final intention of the parties. Is the writing a complete or partial integration? After establishing that the writing was final, one should determine if the integration was complete or only partial. If complete, the writing may not be contradicted or supplemented. If partial, it cannot be contradicted, but it may be supplemented by proving up consistent additional terms. Take note of the word consistent. As with the finality component, whether an integration is complete or partial depends on the intent of the parties. All relevant evidence is admissible for the purpose of making the determination. So you can introduce evidence, okay, that demonstrate whether this is a final expression of your intention or not. That's different from extrinsic evidence to contradict or modify the full and final written agreement. You follow me? No. So there's two phases, right, to parole evidence. What's the first phase? Can I take this off? Okay, so. Okay. Because sometimes you assume there's a writing and nothing in the facts say writing, and then you start talking about parole evidence, and then you're like, wait, was there writing? I don't know. That's something I would do. So just make sure. Okay, just first thing, is there writing? So how do you attack a parole evidence problem? Your first and most basic. Meaning, we're going to call it set one. Evidence to demonstrate this contract A non-final or B. Somebody's going to be arguing it's final. Do you know does everyone know what I mean by final? Like, exactly, okay. Okay, so that's where I'm saying, writings that evidence a purported contract are not necessarily the final expression. Thus, for example, the parties might have only intended such writings to be preliminary to a final draft. Okay, and so the parole evidence will not bar introduction of further evidence. Any relevant evidence is admissible to show that the parties did not intend the writing to be final. Okay? The more complete the agreement appears to be on its face, the more likely is that it intended its interpretation. Any relevant evidence to demonstrate this contract is intending to be final or not final, okay? So if you want to argue that it's not final, what does that mean you want to then do?
Introduce parole evidence to show that something needs to be done.
Correct. You're not going to introduce parole evidence, you're going to introduce extrinsic evidence made prior to or contemporaneous with the non-final agreement. Okay? Which will therefore not be barred by parole evidence. If you understand it, you can kind of do that all day. If you understand it. If it's parole evidence should only be spoken about with the word barred by parole, barred by or not barred by parole evidence. Parole evidence is the barricade to the extrinsic evidence. There's extrinsic evidence, and when it can't come in, you say it's barred by parole evidence. And when the extrinsic evidence comes in, you say not barred by parole evidence. You have to learn to speak the language, yes.
So when you have plaintiff and defensive counsel not final, say it's final, the the court is ultimately the one that makes the decision what extrinsic evidence comes in. Like if you're saying, this paper dated June 1st is relevant and it's evidence to demonstrate that this contract is not final. And I said, that doesn't demonstrate that demonstrates
Yes.
it's final. So then that's who makes it.
Yes.
Yes,
So,
we can bring it in.
yes. So anytime we're talking about introduction of evidence, you're already before a court.
Right.
So the court is going to be make the determination of whether or not the relevant evidence demonstrates that it was not final or it was final.
No.
Some rule.
Yeah, as opposed to some rule.
Right. That's what she's saying, like, maybe the lawyers will determine it or something.
Yeah.
Well, the lawyers are just there to determine are these facts of this case good enough for me, or the issues good enough for me to take. You may know that you have a completely full and final contract, and you may say, yeah, let's shoot for the stars and attempt to get this extrinsic evidence in, where he told you he'd do something different than what's in the contract.
Like how there's material change per se. These things qualify. Something that says this final is.
When it's a full,
Merger clause. Like, it has a merger clause.
okay, so let's read about merger clause.
That would say that it's final.
So, okay, a merger clause is a statement in a writing reciting that the agreement is the complete agreement between the parties. The purpose of the merger clause, or the full and final integration clause, that's just further proof lending itself to your argument that this is a final writing, and nothing else comes in. The person that would argue and highlight the merger clause in a contract is the one trying to keep everything out. No, nothing else comes in. There were no free car washes. We have a merger clause. Okay? The merger clause is further proof that our complete expression of our intentions is right here. And anything else that we intended was not an intention at all, because it's not in this contract. It's all right here, in writing. So anything else has no bearing, and it's a complete moot point. The merger clause is just there as further evidence that, or it's just this argument strengthener, I guess. That's what they're there in contracts. It's really just a safeguard against this stuff happening. It's just a safeguard. Because you can always argue against it.
But isn't a merger, I'm sorry to interrupt.
Yeah.
Merger clause, when you have a merger clause in a contract, just my words, it's powerful.
It's very powerful.
Right?
It's very powerful. It is saying, this is our full intention of what we agreed upon. Nothing else was supposed to be in here. That's a merger clause. It is only there.
Final and the merger clause.
That's called the merger clause. Yeah. It's only there for one purpose, and that's to defeat introduction of extrinsic evidence. It's parole evidence's best friend is the merger clause. Okay?
So you're reading contract, for instance, that somebody's giving to you, you've been in a long negotiation with them, and you come to terms verbally, and at the end, you give them a contract. You come across the merger clause, full and final. You better damn well read that in detail and go over it.
You better make sure that everything that you would want in a contract, because whenever you draft a contract, you have to be forward thinking, right? So you have to be able to anticipate everything. And that's what your mind is there to do. I was talking to Denise about this earlier. Everything you write, every single word has purpose. Every single word you speak has purpose now. From now and forever of time. You're looked to, not just because of your title, but because of the ability that your brain now has, the skills that every single thing you do has purpose. Why is a lawyer asked to review a contract? Because they're able to see the purpose behind every single word that guy up on the street that has never read a contract before, has no idea what the meanings are behind these words. You now have the skill to understand the meaning behind every single word, and that you understand that every single word has purpose. Because you're going to use every single word now for the rest of your life to either help you or debilitate your opponent. Every single word is there to either help you or debilitate your opponent. So every single word matters. I don't write one email, not even to you guys, without crafting it so that I think you forward thinking, you think, well, could this ever be used against me? Could I explain this away? Would I have to explain this away? And you find yourself doing that every single thing you craft. You know, to my clients, you never craft anything that can be misconstrued or have misinterpreted, because your words have so much purpose now. And that's just the way the cookie crumbles. It's good and it's bad. But so your words are important, and that's parole evidence is there because it's assumed that two people or two corporations or attorneys drafted it with purpose and intention, and there were no mistakes in drafting this fully executed contract, and you wouldn't have left anything out. Why would you leave anything out of your fully executed contract? Your intentions are there, okay? So unless there's a very good reason, anything else, any other evidence is not coming in to contradict that very sacred written document. Because all contracts, small, large, whatever, they're very sacred. Once your signature is there and they're dated and understood, they're sacred. So that's that. So that's parole evidence in a nutshell. But we're going to understand the exceptions. So let me just go over with you the reading that we didn't cover. Okay, so we read Beaver v. Brumlow. Thank you, Jeffrey. Okay, Monarco versus Lo Greco. I'll do that. Okay. We're gonna do 342. David will do that. Diamond, you'll do 349. I want to go through those quickly. Now, are these, we did, because I feel like there's some repetition on these. I feel that we did these already, did we not? Bayway Refining, Sex Saver?
Yes.
Yeah.
Okay. Oh, I'm sorry, I flipped the wrong way. I'm hungry. Okay. Okay, so then we're at Kanai Chrysler versus Dennison, consideration. We're gonna go to, from those two cases, from 349, we're gonna skip to 375, and that's you, Mr. Maldonado. 375, Austin versus Laurel.
Okay.
Okay?
Right now?
No.
Oh, okay.
Class is over.
Oh,
Where you have it? Okay, good.
359?
And then, did you already do Odorizzi versus Bloomfield School? Did we do that like a long time ago? No, right? Okay, 381. Jackie, you're doing 381, okay? I will do the next two. Okay. Okay, just because it's a fun one, we're gonna do it very quickly, page 400. Arturo, you're gonna do that.
Which one?
400. Vokes beat Arthur Murray, that's a fun one about dancing.
You want me to
just-
do,
Yes, 381 and 400.
I place it, please,
Fine, 375. You know what I meant. Okay. That's a one about a kooky lady and she wanted to be an expert dancer. And she went to Arthur Murray Ballroom Studio and she didn't become an expert dancer, but she was like 65 years old. Not to say that you can't become an expert dancer at 65.
He was the old guy in the classroom when he was first.
But it's like, it's a really funny case because she sued. She sued on this. They didn't make her into a top performer. Anyway, so we have to do that case because it's kooky. And then we're gonna go right into parole evidence, okay? So 407 and 411, I want two at a time. Who's gonna take them? Come on.
Danny versus Russell.
And the next one.
So I take 407 and 411 Massachusetts.
Okay, who's gonna do Bollinger? Yeah, that's a good one to take. That's a good case. He already got it. You're gonna take 416 and 421. No, not you, Denise. No, you're gonna do Greenfield and you're gonna do Trident, 425 and 430. Yes, Greenfield and Trident. Okay. Who's gonna take the next two? 440 and 448. Don't be shy, Jeremy. Okay, Jeremy.
What?
440 and 448. I'm making this really easy because I'm trying to be efficient. Okay. Yeah, perfect. Okay, perfect. Thank you for coming. Bye-bye.
Bucket of chicken.
What? Bucket of chicken. The last time I had a bucket of chicken was February 22nd. It was great.
You got any Jollibee chicken?
KFC, I went to KFC, got a bucket of chicken.
No way. You ate it all?
I did. But it was, look, you have to do those kinds of things with full intention. I did it with full and final expression of my intention. Because before that I had 2 slices of New York style pizza. So I don't do things halfway. I don't partially do anything partial.
Who's that? Is that Jollibee?
Churches.
Chowkey.
Churches.
Oh, Chowkey.
And if anybody has questions, feel free to
I
email me.
love chicken.
And you're gonna get your exams back next week and we can go over them if you want. Or not.
Nah, I know what it's screwed up on.
Sir, you didn't assign the readings, are they going through those cases? Or just the ones you assigned?
Either I will cover them or I'm expecting you to read them.
Okay.
Because we go over, I mean, I can either do 2 things. I do less explaining in class, which means you have to do more of it on your own, but I don't think you learn as much with just briefing the cases. So we can talk about that, but I just more intent on the understanding versus just the briefing cases. You're expected to still read them. You're still expected to read them.
Right.
Because anything that's on the syllabus is conceivably testable.
Right.
It's just 8.
What? Did you say grammar? Oh, great man. I'm gonna call you grammar.
Do you feel like you understand full evidence?
Not a yeah. I studied that.
You studied what?
I read it.
You read what?
Parole evidence.
Do you feel like you understand it?
Now I do.
Oh, no problem. So we'll do that again on Wednesday.
Huh?
You want to come 4:30? Yes. Okay, so does that time work for you, or you want to do 5?
You're sick? You got sick too?
If you
huh?
want to come earlier, you should come earlier. Okay, great.
Nothing to do.
I'll text
No, you overworked yourself, I think.
You know why you're doing all those double shows, right? That's up to
Yeah, you overworked yourself.
You've been doing double shows, right?
Girl, I told you.
Okay.
Do you have work
Yeah, no, you are.
So you read.
Do you have work tonight?
It's not easy. It's not easy.
Thank you.
Of course, thank you.
Don't do it at the end of the
Muscle. Tell your muscle that it works.
You're sick while you're working, bro.
You said, the charitable contributions.
Oh, yeah.
Remember?
Yeah.
If they're disallowing this. You guys take it.
Thank you again for that one, by the way.
You can do a charitable contribution there. You can just
Take care, I'm grateful.
you're actually intending to help.
Stop.
Bye.
Is that what I said? Tell me what you said, what she said.
What? No, what she's saying is the one that you said works.
What?
She's my subscriber now.
That's funny.
That's what you were saying.
I shouldn't have said that I finished my brief.
What?
I shouldn't have said that I finished my 375.
Oh, why
I
you
gotta
didn't?
sign another